One of the things about our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
And welcome to the show. Today, our topic is what transaction structure and when. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel. You can find us on YouTube, X, and Facebook. On each of those platforms, you can find us at the handle @InRem Podcast. Go there, subscribe, like our channel, leave us a review. It helps us out a ton. Also, you can download an audio version of the podcast. Go to Spotify, Apple Podcasts, or whatever is your preferred podcasting platform. You can go there, download it, listen to it over the weekend while you're doing yard work. Again, subscribe, like, helps us out a ton. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So my legal update today is an update on the Corporate Transparency Act. So we've had movement a little bit, but nothing's changed. So on January 23rd, the Supreme Court, in the case of the Texas Top Cop Shop, ruled that the injunction, nationwide injunction that was put in place in that case is stayed, that there is no injunction. So they basically set aside the injunction and said that FinCEN could go ahead and continue to enforce the Corporate Transparency Act and the beneficial ownership interest reporting. So if you remember, just a little history of that case, and on December 3rd of 2024, the court in Texas, so it was the Eastern District of Texas, a judge in that court entered a ruling finding that they believed that the Corporate Transparency Act was likely going to be determined to be unconstitutional. And as a result, they entered an injunction effective nationwide, basically banning the FinCEN, which is the department that handles all the reporting, from enforcing the Corporate Transparency Act. And then on December 23rd, the Fifth Circuit, on appeal from the Department of Justice, ruled that a three-judge panel ruled that the injunction should be set aside. And then on December 27th, 4 days later, the full Fifth Circuit, so all of the judges on the Fifth Circuit considered it, found the panel to be incorrect, and reinstated the injunction. Well, then the Department of Justice quickly appealed on December 31st to the United States Supreme Court. And then on January 23rd, the United States Supreme Court heard it, sided with the federal government, and basically set aside the injunction. So everyone initially were like, oh no, we're going to have to comply. However, once again, Texas, the Eastern District of Texas, there was another case that was pending, and it was the Smith versus United States Department of Treasury case. And it kind of flew under the radar because everyone was focusing on the Texas Top Cop Shop case because that was going through the Court of Appeals and to the Supreme Court, and it was pending in the Supreme Court. But on January 7th, another judge, a different judge in the Eastern District of Texas, in the Smith versus United States Department of Treasury case, entered an injunction in favor of the plaintiffs in that case, enjoining the federal government from enforcing the Corporate Transparency Act, and then issued a nationwide stay on its enforcement until all litigation or there's a binding determination as to its constitutionality. So basically saying, look, This should not be enforced until such time as, this issue has made its way through the entire court system and we have a binding enforceable determination regarding its constitutionality. Well, that decision has not been appealed by the Department of Justice or by FinCEN, and there's a lot of speculation out there as to why. Obviously, the dates, make kind of sense. January 7th, Trump was inaugurated January 20th, and he actually put a freeze in place on any regulatory action. Whether or not that freeze would bar them from appealing, I don't know, but it's a different administration, a different political view on regulation, and as a result, there's speculation that maybe they just don't appeal and that stay just stays in place, because that could be the easiest way to deal with this issue. Let it work its way through the court system. Also, multiple bills have been introduced in Congress, one in the House, one in the Senate. The one in the Senate is called, I like the name, so I'm going to say it, Repealing Big Brother Overreach Act. And so they've introduced this bill, and they're basically trying to undo or set aside and repeal the Corporate Transparency Act. Whether or not they have the votes and it'll actually come to fruition, we don't know. But keeping the stay in place allows for that opportunity to repeal this without having small businesses, which is who's being affected and impacted by this is the small business. Having small business owners, have to manage and maneuver red tape and bureaucracy, and even hire CPAs and attorneys to make sure that they file this stuff properly and in compliance with the act. It avoids them having to do this. And so as a result, keeping the stay in place, if that's your political, view on government involvement and regulation and oversight, if you want limited government, then, and that's what the administration's position is, then they probably won't appeal it. Now, with that said, the Trump administration has not come out with an actual position on it. So they've not announced their position. But as of right now, no appeal has been filed by any agency within the Trump administration. And so we'll see what happens. So I say all that to say, because of this court ruling in Texas in the Smith case, and that stay having been issued and no appeal of that stay having been made and no ruling from a higher court, at this point, that's a binding and enforceable order. And so the filing with FinCEN, the beneficial ownership interest filing with FinCEN is only voluntary at this point. It's not compulsory. And there are no penalties for not submitting this information to FinCEN. And so we'll just have to wait and see, and we'll continue to provide you updates as things change.
All right. Thank you for the legal update, Sean. The Corporate Transparency Act is the gift that keeps on giving. I'm sure we're going to get more information about it as it happens. The drama is not over. Couple announcements. Make sure to join us this afternoon, 3 p.m. Arizona time, for the Creative Finance Collective. That's your chance to sit and ask questions to creative finance professionals. So professionals, mainly lawyers in the space of creative finance, get together for an hour every week to talk all things creative finance, issues that we're seeing, problems, risks, advantages, so on and so forth. And we talk about it from a legal perspective. But we take questions throughout. So this is your opportunity. If you've ever had a question or an issue, or just wondering about the mechanics of creative finance, and you want to hear it from lawyers from different locales, different states, maybe you just need a referral to a lawyer in a particular area. Sometimes we can help with that, because there aren't that many attorneys that practice in the area of creative finance or have focused on those issues as a matter of being a practice area for them. So make sure to join us 3 p.m. Arizona time. We're on Facebook, X, and YouTube. Go there, and we're there as long as we're getting questions. And once we stop getting questions, we move on. So make sure to be there. Enjoy meeting you and answering the questions that you have. All right, so we're going to get into our topic today. And Sean and I wanted to break down transaction structures that you look at and face when acquiring and disposing of real estate, and talk about when you use those, well, what those transaction structures are, when you use them, what they mean, when it makes sense to use different ones, so that you're prepared for, on the acquisition side, so you're prepared not to be surprised and you have a good strategy going into that. So we're going to break those down for you here in today's episode. So Sean, jumping into this, we want to kind of just give a survey of where things are at when somebody looks at acquiring real estate. But, in our estimation, there's really kind of two, if we wanted to break this down into the most basic way to look at it, there's really two ways to look at a transaction, and one that somebody might approach it from. And that's, title actually be conveyed at the time of sale, and title not being conveyed at the time of sale. Why don't you kind of break down what that means, so we have kind of a base level understanding as we approach this topic?
Yeah. So basically, there are two basic documents that can be used for acquiring or selling real estate. The first is your warranty deed. So that is a deed to the property. The title is actually transferring and conveying to the purchaser or the buyer of that property, and they will be the record fee title owner of the property upon receiving and recording that warranty deed. The second conveyance document is, in Arizona, we call them agreements for sale. Other states call them land contracts, contracts for deed, bond for deed. They have all kinds of different names throughout the country, but in Arizona, we call them agreements for sale. And that actually is a conveyance document, but it is conveying all rights and interests in the property except for the actual title. So you're receiving the right to possess the property, the right to improve the property, maintain the property, to pay taxes on the property, to insure the property, basically to lease the property, sublease, or lease the property. You basically are given all rights of ownership, except title remains in the seller's name to secure your performance under that document. So what that means is you've agreed to perform in the future, and until you fully performed, so whether that's generally it's a monetary performance, so you've agreed to perform monetarily in the future, and until you perform, the seller keeps title. It's very similar to if you purchase a car via financing, and the title does not go to you, it goes to your lender. So your lender holds title to that vehicle to make sure that you are actually going to pay the loan as you're required to pay. And until you pay that off and fully perform, you don't get title to the vehicle. It's the same concept, but with real estate.
Yeah, and we've all paid off our car loan and then got that title in the mail, right? And that's basically
right.
it.
That's it.
Yeah. So still kind of taking this from the foundational level here, when we talk about kind of conventional transactions out there in the market, at least as we understand the term conventional, that's really going to make up the warranty deed side of things. Most conventional transactions involve that, right?
Yeah. If you're not going to have a performance in the future, you should just acquire the property by warranty deed. There's really no reason not to take title. So if you're obtaining your own third-party financing, you are paying cash for the property, any of those types of situations, you're going to want to just take title through warranty deed. So your your traditional purchase and sale, nothing creative, no seller financing, no wrap or subject to, none of that. If it's just a traditional sale, yes, warranty deed is the way to go.
So let's start by breaking down the conventional side of the equation and understanding, okay, the conventional side is going to be conveyance of the real estate is going to happen at the time of sale, basically. You mentioned that involves a warranty deed, but you've had a number of legal updates breaking down different deeds. There's different types of warranty deeds that are used in different types of situations. Why don't you explain that?
Yeah, so the two types of warranty deeds are general or special warranty deeds. If you're a purchaser, you want to try to obtain a general warranty deed, which is a warranty deed that in which the seller or the grantor of the deed warrants title to the property all the way back to the history, beginning of time, basically, all the way back. And they warrant the title. So if, 60 years ago it was discovered that there was a problem with the title, that seller has warranted that they will take care of it, that they will be responsible for it. That's when we talk about warranty deed, that's what a warranty deed is. It's warranting title to the property. So a general warranty deed means I'm going to warrant it all the way back, regardless of when the issue arose. I'll take care of it. A special warranty deed. So if you're a seller, you want to negotiate a special warranty deed, because a special warranty deed says, I will warrant title, but only for the period of time that I've owned it. And anything else I'm not warranting. And so that's a special warranty deed. Frankly, title companies will insure both deeds. It's just a matter of, how much warranty you're going to receive as a purchaser and how much you're going to give as a seller. So those are the two different types of warranty deeds.
All right. So within kind of the warranty deed space, let's break down a couple other types of transactions that we might see. Obviously, the most common one we're all used to is I go to some third-party lender, I get financing for a mortgage, they're going to loan the money, I get the deed to the property, and the bank has a lien in the form of a mortgage or a deed of trust recorded against my property. Everybody gets that. We love to talk about seller financing, though, on this show. So in a seller financing deal, are we still talking about the conveyance by a warranty deed?
Generally, yes, because in a straight seller financing situation, the seller owns the property free and clear, so there's no underlying loans. And so you don't have any due on sale issues or concerns. And in that case, the seller basically will be your lender. And so if you're a purchaser, you want to acquire it by warranty deed. And then you basically provide the seller. So the seller gives you title, and then you make the seller your lender by giving them a promissory note secured by a deed of trust or mortgage against the real estate. So basically, it's the same documents you would give to your third-party lender, your conventional lender, but instead of giving them to this other lender, you give them to the seller. So you make the seller the lender, and then you own the property, and then you have to make payments every month to the seller or a servicing agent, however you set it up. But that then you still own it, though, with all rights. Title is in your name, and you have all the benefits of a warranty deed transaction.
All right, so let's move this more to, we're starting from the conventional and we're moving away and moving faster and faster towards the unconventional, but we're still talking about the use of a warranty deed. So break down for us, we have the Creative Finance Collective this afternoon. Let's look at this from a creative finance perspective, and what we hear in the space is like a sub-2 purchase. How is the warranty deed involved in that case, and how's that set up?
Yeah, so for a subject to purchase, I also like to refer to it as a wrap financing purchase. Subject to is used loosely, and it's a newer term. And frankly, other attorneys and judges don't fully appreciate what it means. Basically, subject to just means you're acquiring real estate with the existing loans in place. They're not being paid off. You're taking them, quote unquote, subject to. However, the right way to structure these transactions when a warranty deed is involved is to do wrap financing. And so the wrap financing refers to a type of financing that basically leaves the existing loans in place, and then the seller is given its own loan documents that basically wrap around the underlying transaction or underlying loans to make sure that you as the purchaser are going to perform. So In that case, basically, the seller's loans remain in place, and then the seller conveys the property to the buyer by a warranty deed, and then the buyer gives the seller a note, and part of that note, it can either be the whole note or part of the note is saying, I will pay your loan for you, basically is what you're saying. I'm going to pay that underlying loan. And then that note is secured by if it's an acquisition, for example, if there's just one loan against the property, in that case, you're going to give the seller a second position deed of trust or mortgage on the property, which would then allow them to foreclose if payments aren't being made as agreed.
So we're going to talk about some of the advantages as we move through of alternative ways to structure these things that might not be the traditional conveyance by warranty deed. But there really is a reason why conveyance by warranty deed is the conventional way of doing things. There are benefits to it. There are advantages. There's a reason why it's the most used way by the industry as a general rule. So I think it's worth it. I think there's always a temptation to go run and do the exotic, right? Just for the sake of doing the exotic. And people forget, what are those advantages to just doing the boring old thing that we've always been doing? So why don't we break that down when we talk about a warranty conveyance? Break down for us, the advantages to that. And we could start from the investor's perspective. One of those is tax benefits. Why don't you break that down for us?
Yeah. So, I mean, these are tried and true tax benefits for investment real estate. In particular, rental income real estate is number one. If you do seller financing, whether straight seller financing or some type of wrap or subject to financing, you can claim the mortgage interest deduction with a warranty deed purchase, and there's no question that you can do it. In fact, there's opinions that talk about subject to and wrap financing right on the IRS's website as far as who can claim the mortgage interest deduction. Mm-hmm. And then second is you can claim the depreciation, and you have that benefit as far as the depreciation for the real estate, and then you could potentially separate out personal property and do an accelerated depreciation on that if it makes sense. So that is well established, and there's no questions on that. You have those tax benefits. So that from that perspective makes sense. If I'm an investor, I want to try to acquire it by warranty deed.
What about in the seller finance subject to transaction space when dealing with a warranty deed? There's bankruptcy protections with that as opposed to the alternative, right?
Yeah, so there's strong bankruptcy protections if you acquire the property by warranty deed. So basically, the one risk that you have, whether it's straight seller financing, potentially could even have the risk just a traditional transaction. But the risk that you have in any of these transactions is that the seller goes in and files bankruptcy within the first 90 days from the date that you close on the deal. So within that 90-day period, anybody that the seller does business with, contracts with, out of the normal and ordinary course of their dealings, is subject to basically avoidable preference, which means the trustee can come in and say, okay, I'm going to unwind this thing because it makes sense financially, and I can use the asset to pay creditors. They have to put the parties back in the status quo, but they could do it. Once you get past those 90 days, assuming that there's, they can't establish any type of fraudulent conveyance or transfer, which is hard to prove, then and that's only for a year, then you're pretty much home free with a warranty deed, even if you've purchased it with seller financing or subject to wrap financing. You're pretty much protected because you actually own the property. It's not an executory contract, which is a contract that's to be performed over time. It's actually a performed closed contract. receive the deed in exchange for you giving a promissory note. Promissory note is basically like a check. It's a payment. But it's just a payment that's made over time. So when you give them the promissory note, that is your payment for that property, and it's performed. There's no, future performance. Now, the promissory note could end up being an asset in the bankruptcy court and sold, but that doesn't concern you because they may come to you and say, "Oh, make your payment to so-and-so instead of the seller," which you don't care as long as you can continue to make your payment and hold title to the property.
So talk to us about options after the purchase and why the warranty deed can be a benefit and a good to the transaction. It gives you more options in the disposition, doesn't it?
Yeah. So if you're an investor acquiring the real estate by warranty deed, then you basically can do a disposition however you believe is appropriate. Obviously, complying with different federal law requirements or state law requirements, depending on what state you're in. But you can do a traditional sale. You could do a seller carryback. You could do wrap financing where you keep the existing loans in place and do your own wrap financing. You can do an agreement for sale. You can do a lease with option to purchase. Basically, you're not limited on your dispositions when you acquire the property by warranty deed.
What about financing options?
So that too it's the best for financing. So let's say you go in and you acquire this property and you look around, you're like, oh man, this thing's like, needs some work. And so you go and you find a hard money lender who of course wants a lien against the real estate. Well, if you own it by warranty deed, there's no issues there. You could just provide a promissory note to that hard money lender. They take a lien against the real estate. You use it to repair the property. And then you subsequently either pay them off or do some workout, or you sell the property if it's a fix and flip or something like that. But, your ability to obtain secondary junior lien financing is open versus, as we'll talk about, an agreement for sale, it's going to be more limited.
All right. So what do you think are the disadvantages to conveying real estate by warranty deed?
Yeah. So from a seller's perspective, and this could be an investor, right, who acquires a property and wants to do a disposition. From a seller's perspective, the foreclosure periods can be longer. So you may not want to do it. So for example, in Arizona, it's a 90-day foreclosure process. It's going to be shorter potentially with an agreement for sale. And then here in Wisconsin, where I'm also licensed, it's, if it's depending on whether it's homestead, et cetera, I mean, you're talking potentially a 1 year finance or a foreclosure process after redemption rights and everything like that kick in. And it will be shorter with a land contract here in Wisconsin because you can do a strict foreclosure, which we'll talk about in a little bit. But, you're talking longer timeframes for foreclosure. And so from a seller's perspective, you may not want to do this type of transaction. You may want to try to accelerate your ability to get the property back quicker.
Yeah. So another thing that comes to mind when talking about disadvantages, we've talked about this, and I'm hoping you can break this down in a little bit more detail, but in a subject to transaction, the biggest concern usually out there is the triggering the due on sale clause, which undoubtedly is triggered in nearly every subject to transaction, if not all of them. If the transaction's dealing with the conveyance by warranty deed, is it a bigger risk that the due on sale clause is called in that scenario versus not conveying it by warranty deed, the alternative?
Yeah. So that a warranty in the subject to realm, a warranty deed transfer does create the greatest subject to risk. Number one, the buyer is now on title to the property, which the lender can easily pick up by if they audit their files. Number two, there's certain loan types like VA loans where you shouldn't do a subject to transaction by warranty deed, but it's workable by an agreement for sale, for example. So as far as the due on sale risk, yes, it does pose the greatest due on sale risk. With the other transaction types, in particular agreement for sale, could the lender potentially call the loan? Yeah, but it's not as likely, and we don't see it as often.
All right, so that is the traditional way of conveying real estate, and the types of transactions that fall under it. The conveyance by warranty deed, where full right title and interest to the property, both equitable and bare legal title, is conveyed at basically at the time of sale. As we discussed kind of at the beginning of the program, there is a way to not transfer the bare title of the property at the time of sale, but transfer an equitable right in the property. And we in Arizona call that an agreement for sale. In other states, as Sean mentioned, it's referred to as a contract for deed, and land installment contracts is another version of it that you might have heard. It's a different form of transfer, maybe a little bit more exotic than the traditional, but recognized by many states. In Arizona specifically, we have a body of statutes directly related to land installment contracts, agreements for sale. So they are a thing. They're an appropriate thing to use in an appropriate circumstance. So let's break down. I don't want you to necessarily have to redefine what it is, because you kind of went into that in the beginning, but why don't we just start, when did we commonly traditionally see an agreement for sale used, at least here in Arizona?
So straight seller financing, where the seller wants to basically, at least initially, shorten those, we call them forfeiture, but foreclosure or forfeiture time periods. So for example, in Arizona, if you use a servicing agent to collect the payments, so a licensed servicing agent, and there's a number of them out there, and they're collecting those payments. If the purchaser fails to make the payment, if 0 to 20% of the balance has been, or principal balance has not been paid, no, if only 0 to 20% of the principal balance has been paid, then the seller can basically do a forfeiture upon 30 days notice. And so, that's a accelerated time frame, and they don't even have to go into court. It's a process out of the court system where they basically give the right notices of an intent to for forfeiture. They do a notice of forfeiture, and all of a sudden now that purchaser no longer has an interest in the property, and it's only 30 days. In Wisconsin, for example, you can do a strict foreclosure on a land contract, but you can't do a strict foreclosure on a mortgage, which then accelerates the redemption time periods to, as short as 7 days. And once the lawsuit's been filed and served and all that, because you have to foreclose through judicial action. But the other advantage, and this is, I think, overlooked a lot of times, is if you foreclose a deed of trust or a mortgage, you're going to put the property up for sale, and anybody can bid at the sale. But with a agreement for sale or a land contract, there is no sale. It's a forfeiture, or in Wisconsin, a strict foreclosure, which means that there's no ability of a third party to step in and take that property. Now, you get paid in full, and maybe you're fine with that, but that ability isn't there. And so if your goal is to get the property back, maybe it's gone up in value, and you think, oh, well, not only, do I have this amount that I'm owed, but the property is worth more than that, so I can come out ahead. You can do that and accomplish that with an agreement for sale without risk that a third party is going to show up and buy it from you. And so that's another advantage from a seller's perspective is, not only do I shorten the time periods, but I can make sure I get the property back, and I don't have to compete with third party bidders.
It can also be used in lieu of a novation. Why don't you explain that and what that means?
Yeah. So the way a novation works is a novation from a legal perspective is replacing one contract with another. And so basically, there's investors who end up with sellers who enter into contracts with other buyers, and there's a whole process that they go through as far as utilizing attorneys in fact and powers of attorney and things like that. It's my opinion that the proper way to do what they're trying to accomplish is not through the quote unquote novation method, but using an agreement for sale or land contract on a temporary or short-term basis, because there's no restriction as far as the time of performance under the agreement for sale or the land contract. You can have a 60-day performance period or a 90-day or 120-day. And by doing that, then you basically have control of the property for that period of time, and you can list the property on the MLS. You can try to flip it. You can make improvements to the property. It's basically your property for that short period of time, and it gives you the ability to basically utilize it in that manner and method. And as long as the seller gets paid its final payment as you've agreed to in the land contract or agreement for sale, then you're free to do with the property as you may during that time period. And if you don't perform, then they can, either forfeit or do a notice of cancellation or something like that, depending on what the parties agree to.
Now, you like its use also in the context of VA loans. Why don't you break that down?
Yeah. So the VA servicing manual, so the manual that's published to those that, and the rules that govern those that collect payments for the VA, their servicing manual says that their position is that an executory contract is not an event that invokes the due on sale clause. And so the agreement for sale or land contract is an executory contract. It's not a contract because title remains in the seller with the seller. It's not a contract that's fully performed. There's been no conveyance of title. And because of that, it's an executory contract that's supposed to be performed over time. And because it's an executory contract, title companies will close escrow and insure contracts for deed or land contracts or agreements for sale for VA loans, but they won't generally insure warranty deed transactions for subject to VA loan transactions by warranty deed, because there's not that exception in the servicing guidelines.
Now, we've kind of been, even though we've been talking about the use cases for the agreement for sale, obviously in defining the use cases, we're talking about some of the advantages. So there is some overlap here, but one advantage I know clients and folks like with the agreement for sale, I know it's something that you like, is there's just less paperwork involved. Every time you do a seller finance, whatever, whenever the seller's carrying, the lawyers want to, rightfully so, bring to bear a lot of documents to help document the transaction. You just don't need as many in the agreement for sale. Why don't you explain that?
Yeah. So basically, the agreement for sale or the land contract, if drafted properly, right? So that's the key. You have to draft it properly. But if drafted properly, it can be your purchase agreement, your conveyance document, your note, and your mortgage or deed of trust, all wrapped up into one document. So the way that would work is you have your agreement for sale or your land contract, and it has the provisions similar to a regular purchase contract, as well as the seller financing provisions. And so normally it has to be notarized to be recorded. But in order to open escrow, you just need signatures. And in order to have an enforceable contract, you just need signatures. And so it acts as your purchase contract, because you can go to the seller and you can have the parties sign and date the agreement for sale or the land contract, and then you deliver that to the title company. and they can open escrow with that land contract. Earnest money can be paid, the whole thing. It basically is there in escrow. You can do inspections, you can get title reports, you can get title insurance. You basically run it like a normal escrowed transaction. Then once any closing costs have been paid and prorations are done, and any cash at close has been paid, once everything's ready to go, like a regular transaction, ready to close escrow, then the title company actually gets notarized signatures on the agreement for sale or the land contract, and then they record that document, and then that is what effectuates the close of escrow and the conveyance of all rights and interest in the property other than title to the purchaser. And then that document then says what the purchaser is required to do as far as payments go, and then what the seller's remedies are if they don't pay. So basically, it's everything wrapped up into one nice, simple document. Now, if you are acquiring the property subject to, there's going to be some corresponding documents that you're going to want executed, such as assignment of insurance proceeds and authorizations to release information so you can at least find out what's going on with the underlying loans and things like that. I mean, there's other things to obtain, documents to obtain, but this can serve as those 4 documents wrapped up into one.
Now, one of the things that we note as an advantage, and we've talked about this, you talked about this with regard to the VA, a lower due on sale risk in terms of, just triggering that clause. Now, in the VA context, there's express language that essentially exempts out that transaction or does not consider that. I know you've studied a lot of due on sale clauses from the different lenders, so on and so forth. Most of the time, I guess, well, they're really all over the board, right? Some are, vague in how much they cover. Others are very broad in what they cover. Have you, other than the VA, run into other due on sale clauses that expressly exempt out executory contracts?
No, most due on sale clauses are going to prohibit the conveyance of even an equitable interest in the property. And some of them even expressly state, the language contract for deed, agreement for sale, land contract, or similar document. No, I mean, technically it's a violation of the due on sale. The question is does the lender, turn a blind eye? Number one, even know about it, because the deed and title is still remaining in the seller.
Right.
And then if they do know about it, do they kind of turn a blind eye just because the seller has so much more control over the property in theory than in a warranty deed transaction? And the other big thing is, and we talk about this on the collective, is there are a few loan servicers out there who will use updated insurance documents to find out if there's been a conveyance and trigger the due on sale. So the nice thing about an agreement for sale is the insurance is structured a little bit different. So in a warranty deed conveyance, because title does pass and transfer, that seller does not, even if they're the borrower on the loan, it doesn't matter. They do not have an insurable interest in the property because they don't own the property anymore. They have no further interest in the property. And so the only interest that they might have is if, assuming, and they should take a wrap or some type of carryback financing loan, the only interest they have is as a mortgagee, and can be listed as such, or having an additional interest in the sense that, the borrower of a loan secured by the real estate, but they're not the owner. So they should not be, the primary insured under the policy. But for an agreement for sale, because they still are the record title holder, they do have an insurable interest in the property. And because they have an insurable interest in the property, they can remain as the primary insured. And then you put the purchaser on as the additional insured in that case. And so when the insurance policy gets submitted to the lenders generally don't really concern themselves with who's added as an additional insured. They just want to make sure that the primary insured remains the borrower. Now, not all servicers are like this. There's only a few that, like I said, will follow up and send it off to their loss mitigation department for determination whether the property's been conveyed in violation of the due on sale. But with the agreement for sale, it's not going to trigger that because the primary insured will continue to be the seller.
All right. Let's move to disadvantages of the land contract or the agreement for sale. Now, obviously, we've kind of already talked about the disadvantages are really the inverse to the advantages of the warranty deed. The first one we discussed is there's greater bankruptcy protection in the warranty deed. There is obviously, for the reasons that you expressed before, less bankruptcy protection dealing with an agreement for sale because it's an executory contract, right? And it can be basically voided by the bankruptcy trustee if they decided that there was value and that was something that they wanted to pursue. And you don't necessarily have to rehash that, but on the tax question, I think one of the reasons we say that there are more advantages to the warranty deed is that on the agreement for sale or land installment contract side of things, it's the law is kind of gray in terms of what you can do and what you can't do. Just because I think it's just not a conventional transaction, right? And so there's some question as to can you take advantages of the same things that you could have taken advantage of before? Can you add further explanation of that?
Yeah. So I believe it's pretty well settled that you can, if you're the one paying the mortgage interest, you can claim the deduction. So that's a settled thing, whether it's under an agreement for sale or a wrap financing transaction. Won't apply in a lease with option to purchase, which we may get to, but we'll see. But the depreciation is going to depend upon, the CPA and their interpretation of IRS decisions and that type of thing. So, whether or not you can claim the depreciation, whether or not the IRS would take issue with you claiming the depreciation, that's kind of an unknown at this point. It depends on the CPA you go to, whether or not they would recommend being aggressive on that or not. It's kind of an open question. So that is the one downside within the agreement for sale, because you aren't actually taking title. So it kind of creates a little bit of a gray area as far as the right to claim depreciation on the assets.
We also have listed as disadvantages is the fewer disposition options and subsequent financing is difficult. Does a lot of that have to do with the fact that most oftentimes in subsequent financing, you're dealing with conventional third-party lenders that just aren't willing to lend on following that kind of transaction?
Yeah. So on the financing side, in theory, it's allowed and it can be done. In theory, you can basically finance and obtain a loan and secure it by your equitable interest in the property through the recording of a deed of trust or mortgage. But a lot of lenders, they don't appreciate that because they're going to want to look at the title to the property and say, okay, who's on title and who's giving me or who's taking out the loan? And that's the issue, right? But in theory, a lender could obtain a promissory note and secure that interest by a deed of trust. But if they foreclose, the only thing that they're taking out is the equitable interest of the purchaser, and in which case they would basically stand in the shoes of the purchaser at that point, and be able to, make payments on that, pay it off, whatever they're going to do. Now, you want to make sure, and that's the other thing, you want to make sure that the language of the agreement for sale allows for that. Because a lot of times the agreement for sale will say that the purchaser cannot further encumber the property or allow liens to be recorded against the property, et cetera. That's going to be the standard language in most agreements for sale or land contracts. So if your goal is to obtain some subsequent financing, you think you can pull it off, you better change that language from the standard provisions into, the proper provisions. The other thing from an acquisition standpoint, when we talk about disposition options, is the standard language is not great on regular, agreements for sale or land contracts. So if you go frankly, to an attorney that doesn't know what they're doing in the space. Maybe they know land contracts or agreements for sale, but they don't really understand, the investor space like they should, or, subject to acquisitions, dispositions, or you go and find a form somewhere, online or that's available. Those forms are going to have language in there that basically prohibit you from assigning the land contract, from further doing a secondary land contract, from in any way alienating your interest as purchaser under the land contract. So now your options are way limited. You cannot. You may not be able to get subsequent financing. You may not be able to do a secondary land contract. You may not be able to do a lease with an option to purchase. You might not be able to do an assignment of the land contract. Let's say that you have a great deal and somebody's like, hey, I'll give you X amount of dollars if you just assign me your purchaser interest. Well, you want to be able to do that, but if the language doesn't allow it, you're not able to. So you want to make sure that you've opened the door for those options, and the language isn't limiting those. But the one thing that you can't do is you can't do a warranty deed purchase to an end buyer, because you don't have the warranty deed in your name to begin with.
Right. Yeah. We got a little bit of time left, so why don't we jump to the third type of transaction structure that doesn't get a lot of attention all that often, but that's the lease with the option to purchase. Why don't you break that down for us?
Yeah, so a lease with an option to purchase is, in my view, kind of your transaction in last resort. And the reason why you might want to do the lease option is because it is the greatest protection against the due on sale. There's other than maybe recording a memorandum and maybe securing that with a deed of trust or mortgage, or securing your option with a deed of trust or mortgage, there's really nothing that's recorded that actually conveys any real interest in the property to the buyer. And plus the Garn St. Germain Act says that you can, as a borrower, you can lease the property for up to 3 years without violating the due on sale clause. And it doesn't say, what that, if extensions apply to that. So you could lease it for 3 years with potentially, it's a gray area, but potentially have extensions beyond that for up to 3 years. And then on the option to purchase, you could either do an option to purchase, or you could even do a purchase contract with a, extended escrow time period. And then I've never seen a lender call a loan due based upon a seller entering into, or a borrower entering into a contract to purchase. I mean, if that were the case, they'd be calling these due on sales every time it's listed in the MLS and escrow is open. But they don't pursue that. Right. Could they? Maybe, depending on the language of the due on sale clause, but they don't, because it's just a purchase contract. And so, a lease. So it's a master lease, which gives you the ability to sublet the property, to maybe make some repairs to the property, to maintain the property. It gives you a lot of rights with respect to the property. But the one thing you can't do is the seller will, as the landlord, will always be responsible for habitable maintenance and repairs and improvements to the property. You can't adjust that. There's lack of tax benefits. It's doable, but it's kind of your last resort transaction.
Sure. Sean, we have a question from the audience. Maya, if you would put that up and take a look at it. The question: with an agreement for sale or land contract, does buyer lose out on getting to claim depreciation while deed stays in original owner's name until contract is fulfilled?
Yeah. So Nick, thanks for the question. I did touch on that a little bit. So basically it's a gray area. It's kind of an open question. So you'd have to work with your CPA. Some CPAs are more aggressive than others. And, they can do a little bit of research, see what the IRS opinions are on that, and then decide, whether or not you want to claim the depreciation. And then from there, it would be obviously up to the IRS to, if they ever questioned it, to decide whether or not that was, appropriate or not. But it is a little bit of a gray area, which is one of the downsides for an agreement for sale is, a warranty deed, the tax benefits are tried and true. We don't have to really question them. For an agreement for sale, it's a little bit of an open question, but definitely work with your CPA on that.
Yeah. All right, good stuff. Those are the transaction structure options. And thank you everybody for joining us. Make sure to be with us this afternoon for the Creative Finance Collective. And we will see everybody next week.
Have a good day, everyone.